My name is Professor Herrera, and this is a short presentation of my forthcoming course on judicial review of administrative action in French public law. Judicial review of administrative action is the review by courts of the legality of decisions taken by the administration. It is based on the existence of remedies, and it is one aspect of the rule of law, together with such principles as limitation of power, separation of powers, the hierarchy of legal norms, and the guarantee of fundamental rights and liberties. As such, it is one of the means of the accountability of the administration. The course will first examine the place of administrative law and of a distinct set of courts, especially the Conseil d'État, its Supreme Court, in the French legal and judicial system and in the legal culture surrounding it. The main characteristics of the procedure and the nature of the different remedies will be studied. The special role of the Conseil d'État in French public law will be commented. The main body of the course will consist in exploring the gradual extension of the scope of judicial review. It will be analyzed in detail by studying the pertinent case law with a particular accent on 2 points: the instruments and methods used by the courts and the place of international law. We shall study in detail the instruments and the methods used by the courts, such as procedural rules, standing, and the role of the court in pre-trial procedure, the rules relating to the rights of citizens in administrative procedure, adversarial procedure, the duty to give reasons, the review of the reasons of administrative decisions, especially in areas of administrative discretion, and also the affirmation by courts of general principles of law amounting to the creation of law by the courts. Second, there will be a special emphasis on international law and the place of treaties in the hierarchy of legal norms in the French system. The influence of the European Human Rights Convention and of the case law of the court in Strasbourg will be given special attention, together with other international human rights instruments, such as the Geneva Convention on Refugees. Refugee law and aliens law will be taken as examples. We shall also study liability of the state in French administrative law, because it is an important part of judicial review of administrative action. The rule applying to it, such as fault and no-fault liability, will be examined with attention. One remark. Throughout the course, French administrative law shall be placed into the general European context due to the combined influence of EU law and of the case law of the ECJ and of the influence of the European Human Rights Convention. The contents of administrative law and the scope of judicial review have been changing under our eyes in most European countries, and they have acquired gradually a number of common features. The illustrations are many: the principle of legality, the principle of proportionality, due process of law, non-discrimination, legal certainty, legitimate expectations, the duty to compensate for the loss created by illegal action of the administration, the right to an effective remedy, and the growing influence of international human rights instruments. I intend to comment on the concrete implementation of these rules and principles by a close examination of the leading case law of the Conseil d'État and of the administrative courts, and of recent trends and developments. My intention is to make this course as lively as possible and to maintain a high degree in it. I look forward to seeing you. Thank you.